All right, we are live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning to everyone. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by my colleagues, Justice Singh and Justice Hand. We will be hearing a single case this morning, number 20-68, Commonwealth versus Sylvestre. We are, of course, hearing this argument by teleconference due to the ongoing pandemic. The rules for argument are the same as when we hear argument in person in the courtroom, 15 minutes per side with no rebuttal. With that, we will hear first from Mr. Naris.
Thank you, Your Honor. May it please the court. I just want to start with the something that the Commonwealth suggested in its brief, that the objection for Rule 404 purposes, other bad acts, was not preserved at trial. I think the Commonwealth is clearly in error with that suggestion. If you look at the defendant's record, appendix at 23, I've included the copy of the motion in limine that was filed to exclude the evidence. And while it doesn't specifically mention Rule 404 or use the buzz term other bad acts, it clearly is contemplating the rule, because what it's objected to is that the use of persistent foul language as well as defendant's presence at the House of Corrections is highly prejudicial, which is 404, which is other bad acts evidence. And that's what the objection was.
Using foul language could be characterized as a bad act?
Yes, I think so. I believe it is squarely in the other bad acts type evidence that is contemplated by the rule. Although, as the Commonwealth suggests, the evidence is introduced for other purposes, not specifically just because it's foul language. It is bad act evidence. It is used to cast the defendant in a bad character, to show that he's a bad person, to show that he has propensity to commit crimes. And to be frank,
I'm willing to agree for purposes of argument that that's a past bad acts objection, and that it preserves something. But what you're claiming here is a little different from what you claim below. Below, you claim that there was foul language and that the calls came from jail. And what is really the problem here, I gather, having listened to these rather terrible tapes, is the tone, the tenor, and the abuse of the girlfriend that are woven throughout this. And you did not raise that with the judge.
well, I think it was, I would suggest that while the objection was not perfect below, I think the suggestion was that these calls are highly prejudicial because of the language that's being used, which I would suggest.
Language. I don't think even this repeated and unusual, to me at least, colloquial way in which he uses the N-word, which in lots of cases we would say is terribly prejudicial. I don't think it's any of that. I think it's the horrific abuse he's engaged in with respect to this woman.
Well, I would agree with Your Honor to a degree. I think it's both. I think it's the language, and I do think the language, especially the repeated use of the N-word, and I would agree that at some point it seems like it's not being used in an offensive way. But in other points, I think it is.
To me, that's not where the weight of the problem is here. I listened to an hour of this, and at the end, I was just drained, having listened to the different ways in which he abuses this woman to the point where she is contemplating suicide because of his outrageous and offensive and horrible demands on her, and threats and all of the terrible, I mean, you can't listen to this and think this is anything, but this is a terrible human being. So I agree about this 4.0. Well, we don't have rules here, right? So, but I agree with past bad acts being at issue, although I don't think it was argued this way below. But I also, and I guess I'd say, and I also don't think, and I don't know what to do about this, because I don't think you exactly, maybe you ask us to do this. Some of this has to come in. This is extremely valuable probative evidence. I have no doubt that some of it, the jury has to hear some of this. They have to hear about the Clorox bottle mentioning. They have to hear that he keeps saying to her to go clean the apartment. They have to hear that he, maybe even the bits where he switches and says, okay, I'll take the rap for you, if that's what you know, this kind of terrible, malicious kind of scheming change of tack. They have to hear some of that. I don't know if they had to hear an hour of it. But you didn't say, look, can we put in this? He says at this time and this time and this time, let's get 5 of them in and not hear 100. You didn't say that below. I'm not even sure you say it here.
Oh, I do say it. I would suggest I do say it here because I think that's part and parcel of the reasonable alternatives argument that I make in the brief, is that the judge, one of the factors that the judge has to consider after it comes in as relevant is, by listening to it and making a discretionary judgment based on his consideration, whether there are reasonable alternatives to introducing this. And I think that goes right to the heart of what Your Honor is saying. There were reasonable alternatives. And if the judge had done his job, and I would suggest the judge did not do his job, and listened to the tapes before playing them in front of the jury, then he could have parsed it out.
How did that happen exactly? Below, no one says to him, whoa, slow down, judge. That transcript isn't good enough. You got to listen to it, right? He's busy cutting stuff out of the he or she, I don't know who the judge was, busy cutting stuff out of the transcript in an attempt to redact it. Although then it's quite clear that he is as sort of taken aback, or something that's too strong, maybe surprised by exactly how much worse, I guess, it sounds in the transcript. We don't have the transcript, I don't think, right?
No, that's correct.
So what is that transcript? How did the judge get it? Why was everyone working off it? Can you explain that?
I think what happened, in my understanding from the transcripts in the trial counsel's file, to be frank, but is that the Commonwealth had printed out a transcript that they made and presented it to the judge, and there were redactions that were done on the transcript. But just to go back to your point with the judge, making these cuts, the judge didn't make any cuts. The judge really put it on the attorneys, and I would suggest the judge, unfortunately, didn't do his job. And one of the factors, the main factors, there's a case that just came out after these cases were briefed, Commonwealth versus Pino, which I would point the court to. It's a 2020 August case.
What's the citation?
And the citation to that is I'm sorry, Your Honor. It is 463 Mass 378.
All right.
Oh, wait, I'm sorry. I cited you the wrong case. I apologize, Your Honor. I do have the site right here. It's 485, rather, Mass 378, 2020. And they talk about the factors in considering, and the first one is whether or not the judge gave a proper, thorough review. And I would suggest that didn't occur here. Really, what the judge was trying to do was put it on the defense attorney to make these redactions himself and bring any redactions. I think that judge's, words to the defense counsel was to be candid He had not paid any attention to the calls since making his rulings and was expecting defense counsel to bring redactions to him. Defense counsel just objected to the calls in their entirety.
I agree with that.
And kept going over. So, but I don't think that's the defense counsel's job. I think the cases all make clear that that is the trial judge's job.
When did the trial judge receive a CD or some media that contained the actual recordings?
Well, I'm not sure. I believe the judge had access to that straight throughout the pretrials, and I would assume
Why do you believe that?
They talk about the recordings in the motions in limine when they're arguing the motions in limine throughout trial. I don't think the Commonwealth gives him six calls after the ruling. One of them they have a hearing. Is one of the 6 calls is excluded.
Did you along with your motion? Well, whose motion in limine was it? Yours to strike?
There's a motion in limine to strike. Yes, I believe.
You submit the CD with that?
I'm unclear whether or not the CD was submitted at that time.
How is the judge supposed to listen to the CD?
The Commonwealth had possession of the CD. The Commonwealth had the calls that they were going to introduce.
How did you know to move to strike it? It must have been turned over in discovery, right?
The CD, yes.
All right, so you had a copy too.
Right. The defense counsel had a copy of
Right.
numerous jail calls, including jail calls that weren't allowed in evidence.
Okay, so I'm just trying to figure out, I would have listened to the tape probably, but I don't know that you gave him the CD. You're saying the Commonwealth then presented a transcript and the judge worked from that, I guess. I can't tell. There is a place in the transcript where the Commonwealth says, oh, here's the CD with the redactions in it. And maybe they even say, and here's another one with no redactions, which I obviously that doesn't mean the judge didn't have another copy already, but I don't know. And I don't know how, I mean, it does seem to me that if you're going to file a motion to strike something and you want the judge to listen to it, you have to direct the judge to that. Now, maybe it's something in a file already, but I don't know.
Well, right. And I'm not, to be perfectly candid, I'm not 100% sure whether or not it was presented to the judge as a copy at the time of the motion was filed. But the judge clearly had access to it. The Commonwealth had it. They played it at trial. He could have taken a break prior to playing it to take a listen to it, which he didn't. And I would suggest, Your Honor, there's a case, it's actually cited in Pino. That's why it's not in my brief. I actually didn't come across it until I was prepping for the oral argument. Commonwealth versus Carey, it's 463 Mass 378. It's a 2012 case, which talks about a similar issue where they found error where the judge didn't review a video of a victim being strangled and instead relied on the Commonwealth's description of it. I'd suggest this is a similar situation because the calls, as Your Honor said, are draining. They're awful. And when you listen to them, you get the feeling from them. When you read about them, it's not as bad. But when you listen to this for an hour straight in a very short trial, it's devastating. And the judge, I think, when he did finally hear it at trial, he felt the same way. And that's why he interrupted the calls and gave the curative instruction at that point. And I'd suggest a curative instruction that could not possibly unring the bell. And I think Your Honor hit the nail right on the head. There were reasonable alternatives to playing this full hour, and the Commonwealth knew what was in these tapes.
So why is this an ineffective assistance case? Why isn't this a case where defense counsel, I mean, because you don't find any, I hear what you're saying, none of this was raised below like this. No one said like, you know, you can't play this to a jury. You know, that's mistrial stuff, Judge. This is terrible. Nobody said anything like that.
No,
maybe the lawyer and that way, if it were brought in that posture, because I think, at least, I don't know what my colleagues think, this looks to me like substantial risk of a miscarriage of justice analysis precisely because it wasn't raised in this way, which is the same as loss of a substantial ground of defense. And the judge who actually sat through the trial and will have a better feel for how this emotionally impacted the atmosphere in the courtroom can assess. That's very difficult for us to assess just from listening to the tape and reading the transcript.
Well, I would again reiterate my feelings that, and I think it's correct that the objection wasn't perfect, but it was an objection for bad acts evidence, which put it into the judge's court to act on it. And the judge had a duty to exercise the discretion by really going through this evidence and deciding whether or not it was proper to be brought in the way that it was, or whether there was alternatives. And the judge failed to do that. And I don't think it's ineffective assistance of counsel, because I do think that the objection was made, and I do think it shouldn't be a substantial risk standard. I do think the objection was made and it was preserved for appeal. So I see that my time is up. So if there are no further questions, I would just rest on my brief at this point.
I think we understand your argument. Are there other questions? No? Seeing none, thank you very much.
Thank you, Your Honor.
We will hear from you, Ms. Moriarty.
Good morning. May it please the court, Marina Moriarty on behalf of the Commonwealth. Your Honors, the trial judge acted within his discretion in finding that the probative value of the defendant's highly relevant jail calls was not outweighed by the danger of unfair prejudice, and any undue prejudice was limited by a forceful limiting instruction. I get the sense that Your Honors believe that the rather manipulative way in which the defendant spoke to the victim at some points on the calls is a prior bad act. I would just point out that it was never framed in that way at trial. And so Judge Lang never had the opportunity to assess which is a distinction between a relevance, which is relevant evidence, which might be substantially outweighed by the danger of undue prejudice, versus relevant evidence that is outweighed under the Creighton standard.
I thought the judge actually, I don't remember, didn't the judge actually just say that it was more, the judge didn't say wasn't substantially outweighed. The judge just said, I find it more probative than unfairly prejudicial, right?
Right, correct. He never used the term substantially. And in fact, so
that's the right standard, right? Even if this is a past bad acts.
Even if this is a past bad act, so I would say that, and he really focused on the relevance of this evidence, the fact that it was intertwined, it's how this case came to be. There's really no way to avoid the fact that the defendant on those calls was talking about the drugs with which he was charged, which is to the Commonwealth's point that it's not necessarily an other uncharged conduct, a prior bad act, other bad acts.
It's witness intimidation, right? That's a bad act.
Fair enough.
But which is also consciousness of guilt related directly to this offense.
Right. It's and that's the point, is that his conduct, as abhorrent as it may be, is focused directly on the charged conduct. And I think that's where Judge Lang really focused his attention and recognized that it was simply not persuaded that the danger that the jury would draw a negative inference by the fact that he was in jail at the time, or that he was in using foul language with his girlfriend, was simply not that prejudice was outweighed by the fact of the relevance of these phone calls. So here where it was.
Did the judge have an audio recording?
I don't think the record is clear on that point, Your Honor. It's clear that he had an audio recording by the first day of trial.
Of course, but when the motion was under consideration, I had a hard time understanding why they were looking at a transcript rather than having him listen to the tape and say.
Because I don't think that was the issue, Your Honor. The issue that the defendant raised was related to the fact that he was in custody and was related to the fact that the defendant at times spoke about the prior search, which was suppressed. And so the parties were really focused on avoiding any reference to that suppressed action by the police. So the parties were really trying to parse out specific lines and phrases, and I don't think they were concerned with the overall tenor of the conversations, which is the issue the defendant raises here. So if this is an unpreserved claim, which I would argue that it is, it would be assessed under the substantial risk of a miscarriage of justice standard.
Can you do that analysis for us?
Sure, Your Honor. I don't think there's any substantial risk of a miscarriage of justice here, given the strength of the Commonwealth's case. I would suggest that, well, first, there is no argument that the portions of the calls where the defendant is explicitly telling his girlfriend to go flush the drugs, that has to come in. I mean, there's no way around that. That's the issue in the case. And so I think that call plus the call directing Mr. Vincent to the Clorox bottle, combined with the fact that the police go to his apartment.
Tapes go on for an hour, and there's certainly cumulative evidence in there, put it that way.
There is some cumulative evidence, but I think that the Commonwealth's case was so strong, given the first two calls and given the evidence that was recovered by the police, given Mr. Vincent's explicit testimony that the defendant told her what to do, that these were his drugs, that she knew him to be a drug dealer, combined with the fact that there was no evidence of consumption in the apartment or on the defendant, that Mr. Vincent said that the defendant, she had known the defendant to sell cocaine. I think all of that in the balance would create the risk of the belligerent or potentially abusive language by the defendant towards Mr. Vincent does not outweigh the strength of the Commonwealth case.
What if, here's a question I kind of don't like. What if we think, yeah, the defendant would have been convicted anyway without this, but the jury in their deliberations were doubtless emotionally affected and swayed in reality, in this case, by hearing so much of this? How does that work for substantial risk? I mean, it's not just a question of would he have been convicted anyway, right? It has something to do with affecting their deliberations or something, right?
I don't think that if you can say that he doubtless would have been convicted aside from this,
Doubtless.
I think you can say it's harmless beyond a reasonable doubt. I think you can use the highest standard for error here. So assuming you find that Judge Lang committed palpable error, which is the standard that he had used.
Okay, but it's substantial risk, right? It's unpreserved claim of error.
Well, I think you first have to find that there was an error, and then analyze what effect on the trial that error had, which is the substantial risk standard. And here, I think you can say that you can be confident that the jury was not materially influenced. Perhaps they disliked the defendant more than they would have otherwise, but I don't think that, given the concrete nature of the evidence in this case, given Mr. Vincent's cooperation, I don't think that there was a substantial risk that this materially influenced the jury's ultimate decision.
This is what the prosecutor said at sentencing. I guess what stuck out in my mind and what was significant for me was really hearing the defendant's own voice. And I found them disturbing, to say the least, during the conduct, which was the portion certainly that were played for the trial. I found them extraordinarily compelling. I found that, for sometimes in a busy courthouse where we see a lot of violent offenses and murders, sexual assaults, sometimes drug cases, tend to look differently or feel differently in terms of sentencing, because you don't have that emotional component to it. You don't have, a victim on the stand who's talking about how they have been, abused or assaulted. But this took on a different look for me just listening to those calls and the lengths at which this defendant would go to really obstruct justice, to manipulate. And really, I can only describe it as intimidation of a witness. It was, I thought, extraordinarily egregious, the conduct. And just listening to the way in which he would speak to, I don't know if we're supposed to use her name, so I won't, the girlfriend, I think had a significant impact. And I would indicate that the conduct is really worse than sometimes some of the cases that we tend to see in the court when they come to sentence on any given day. The entire discussion of this prosecutor's memory of the case is the emotionally compelling audio tapes that make this not like a regular drug case, more like a sexual abuse case.
Your Honor, I might offer a different perspective slightly. I don't think that this is, I think that the prosecutor was simply suggesting to the court that this was not your run-of-the-mill possession with intent case that, is normally tried in district court and is, without any insight into the defendant or, his family, or the impact of his family members. This is, in Superior Court where you do normally handle more trafficking weight cases. And it is unusual where you have some insight into a defendant and his, and those people around him, and the way and the lengths at which defendants could go to protect their business interests and to protect their.
Well, I'm not saying that that shouldn't be mentioned at sentencing or anything like that. Obviously, sentencing can go well beyond, but you say it's not a run-of-the-mill possession with intent case. But he was charged with possession with intent. It was a run-of-the-mill possession with intent case in that sense. I don't know, run-of-the-mill. It was a possession with intent case. It wasn't a intimidation of witness or whatever other kinds of abuse or, coercive conduct, or there's that case where the person texts the other person and then they kill themselves. It wasn't any of those kinds of things, but that's sort of what it turned into, isn't it?
I think, Your Honor, that it was a possession with intent case where the prosecutor was arguing for a higher than minimum sentence. Encouraging the judge to look beyond the defendant's bare border probation records, and I forget exactly what he advocated for, but it was some significant jail time given this defendant's culpability, Your Honor, with respect to the drugs
and the bad character he showed and how he dealt with having the drugs and trying to get out of the crime and everything he was willing to do. I'm going to have to think about this. My colleagues may completely disagree about this anyway, but I have to say, after I listened to them, I'm sure you had the same reaction. They're horrific. They're terrible.
Could some of the 20-minute, two of the 20-minute calls been redacted? Some, yes, I think they could have been. Was it an abuse of discretion? I'm not sure. Does it rise to the level of a substantial risk of a miscarriage of justice given the other facts of the case? I would simply say it does not. This was, a case where the defendant told his girlfriend to flush the drugs and then told her specifically where to find the drugs. That he was a bad person and that he was potentially an abusive person who was trying to obstruct justice, that could have weighed on the jury's mind and might have made a difference. And again, but the trial judge simply was not on notice of all these issues. If he was on notice.
I agree with that. But it's not, the question isn't fairness to the judge at the end of the day, it's to the defendant, although maybe this is a failure of counsel. That's how you suggested to your brother. I don't know how you could listen to these and not kind of, make a fuss about them.
Well, I think part of the problem is that they're just so relevant. I agree with that. They're just so, he just expresses such consciousness of guilt in every almost in every sentence. He's like, you can take responsibility. You have no record. You can just go on probation. And then he says, fine, I'll take it. It would have just
I
been.
mean, it also lets them know, although this is inescapable, it also lets them know that he has a past record. You have no record. I'm going to go away for a long time. I mean, look, you take what you get, right? I mean, that's not, you can't redact that. That's the whole, not the whole.
And that's the purpose. And that's, I'm sorry to interrupt. That's the purpose of limiting instructions. And Judge Ling provided limiting instructions before, during, and after the trial. Should he have done a better job? Should everyone have parsed this down? Probably. And then we'd be here on a different issue. But I just don't think it can rise to the level of a substantial risk where none of these issues were raised before, given the strength of the Commonwealth case. And if the panel has no further questions, I'm happy to rest on my brief.
Okay, another excellent argument. Thank you very much, both of you. Very helpful arguments for us. I think we understand the case, and we have your brief.